That means that if there is no case against the same individual for the same alleged criminal conduct, then the ICC can go ahead with the case. The principle of complementarity is not a general judgment over the ability of the system. It's a specific judgment over this specific case. So that means that if there were, for example, national proceedings against the same suspect for the same alleged conduct, then his or her defense team, or even the state that is concerned, can raise a challenge to the admissibility of this case before the ICC and say that the ICC should stop the case because there is already a case that has started before the national tribunals, and it's substantially the same case, and that the national tribunals are genuine about it. They have to demonstrate that. In these conditions, then the ICC would stop the case before it. But if there are no cases, or if the case is about another suspect, or if the case is about different alleged criminal conducts by the same suspect, then substantially it's not the same case. And that means that the principle of complementarity will not be applicable on this specific case. So we are not making a general statement about the Filipino tribunals. We are only saying that for this specific case, at this moment, we are not seeing that there is a legal process in the Philippines about this specific individual and for this specific allegations. If they were, then his defense team or the Philippines can actually ask the court to stop this case if they can prove that there are general proceedings against the same person for substantially the same alleged conduct.
All right. Well, with regards to the interim release, let me just go back a bit on the legality of his arrest. Will the manner of Duterte's arrest, which his campaigns was illegal and tantamount to kidnapping, have any impact on the case he is facing, especially if he requests for an interim release?
Well, I cannot speculate on that. If there will be a request either about the lawfulness of the arrest or about an interim release, it will be for the judges to decide on it. And I don't know if the defense will do it, and I cannot speculate on what the judges will actually decide.
Under the ICC, interim release is an option for suspects, right? What are the common grounds for granting such a release? Have there been any ICC suspects in the past who were granted interim release? Were they ultimately convicted or acquitted?
Well, we need to understand that the principle is to respect the presumption of innocence. So, as a matter of principle, we consider that every suspect is innocent unless and until there is a trial after which he or she are convicted beyond any reasonable doubt. And that presumption of innocence means that the principle should be the freedom of the suspects and not their detention. When the judges issue an arrest warrant, that means that they believe that the arrest of this specific individual is necessary, either because he or she are still committing crimes, or because he or she would not appear before the court and cooperate with it if the court issued a summons to appear and not an arrest warrant, or because they believe that maybe without arresting this individual, they may be creating obstacles or threats to the proceedings, to the investigation, or to the witnesses. So they have to justify that. An interim release can be requested if there is a possibility to put in place measures and conditions to ensure that if a person is released, none of that would happen, and that this person will be brought again before the court if the judges order so. And that means that there is a different set of conditions that needs to be checked. First, in which country this person might want to be released. Does this country accept this release? If the court is ordering certain conditions and measures to be put in place to ensure that he will not be in contact with this or that he will not be threatening the investigation, that he will be brought again before the court when the judges order. Does the country accept its conditions and measures or not, and so on. So, as a matter of general principle, there is all these conditions and questions need to be discussed before the judges, and then the judges will decide whether or not to grant an interim interim release with or without conditions, as I mentioned. It has happened in the past that certain persons were granted interim release or conditional release on different situations, sometimes temporarily for a specific sometimes personal conditions, and then back to the detention center. But again, it would be for the judges to decide on that if there will be a request to that effect.
So even personal reasons?
There has been short releases, for example, for private life circumstances for certain individuals in the past. We, as a matter of principle, respect this privacy, so we cannot actually discuss in details what actually happened, but that was very short moment. And again, it's the judges who decide on the interim release as a matter of principle. They decide also on the conditions and the duration.
And eventually, after that interim release, were they convicted or acquitted?
I don't remember the full details of these different cases, but there is no link between the interim release and the final decision, because the interim release can happen at a pre-trial phase or at the trial phase. It's up to the judges to decide on it and on its conditions and on its duration. And it's not a prejudgment of whether this person will actually be acquitted or not. These are two different and separate questions.
All right. Have there been instances where the pre-trial or the trial chamber considered the actions and behaviors or the behavior of the suspect supporters in their decision making? In theory, how significant could this factor be in influencing the outcome of a petition, a certain petition or interim release, for example?
Now, we have to understand that the judges can only decide based on what is presented before them, either by the prosecution or by the victim's lawyers or by the defense lawyers. So they are not taking into account any other elements that are not in the files before them. So this type of actions is showing support to certain suspects, but it's not part of the findings before the judges, so it cannot be taken into account by the judges. But something that has to be also understood is that the judges, of course, do understand the question of ensuring that the person is brought before them, and in certain instances, the question of whether this person can be kind of at large and not return before the ICC. So what kind of networks or capacity he might be able to use in order to hide can also be taken into account for the questions of interim releases and stuff like that. But it's not about the petitions or the demonstrations or this is, I understand it's supporters showing their support to a certain suspect, but it's not a question that is before the judges. It's not presented to them, so it doesn't have an impact on the proceedings.
How about a certain group actually collected 65,000 signatures, of course, asking for the former president to be brought back to the Philippines and just face his trial through video link whatsoever. And this, I understand, was submitted as a petition by this particular group here at the ICC. Will there be any implication, or will it actually affect will it even reach the court if it is submitted by a civilian?
No, we need to understand that the judges, as I mentioned, can only decide based on what is presented before them by the parties and participants to the proceedings. So if there is no standing for a certain individual, meaning that they are not representing one of the parties, that they are not representing the victims, they are not admitted in a certain way to the legal proceeding, then they cannot make petitions to the judges.
All right. The possibility of securing interim release is really closely watched by the Philippines. It is closely watched in the Philippines. If ever, the ICC has signed interim release agreements with Belgium and Argentina in the past. Are these the only two options for a suspect seeking interim release? How likely or unlikely is it for a petitioner to be returned home or to their home country instead?
Again, I would not speculate on the potential outcome of a potential request. First, we'll see if the defense will present the request for interim release, and then we will have to see what the judges will decide on it. Now, as a matter of principle, the ICC can enter into general agreements for interim release or for other purposes with different states, but can also enter into ad hoc agreements with certain states for specific cases. This will depend on the request and on the willingness of a certain state to accept and to implement the measures and conditions that might be ordered by the judges. So this is something that we prefer not to speculate on. We have to respect the proceedings, the integrity of the proceedings, and to respect that the judges are impartial and they are doing their job in a professional way and based on the legal rules and the evidence that is presented before them.
If in any case an interim release will be granted, what are usually the preconditions and conditions imposed, and how long does an interim release typically last?
Well, again, it's a matter that will have to be decided by the judges. I explained a little bit the general framework of ensuring that the person will reappear before the judges when he or she are ordered to do so, that they will not be putting in danger the proceedings and might and would not be continuing to commit crimes and so on. Now, the technical measures and conditions have to be decided on a case-by-case basis by the judges and have to be accepted by a certain state for it to be ordered by the judges. So I would prefer, as I mentioned, not to speculate, to respect the process, and to respect the impartiality of the judges.
Okay, in the history of ICC trials, has there been a case where supporters of an accused have camped outside at the ICC or even the detention facility, as is happening now?
I know that usually every media love this type of questions about the first to happen before the court, and I know also that for every single situation and for every single country, they feel that their case is a bit different from the others. But the reality is, for us, all the situations are very important. They are all about very serious and grave crimes, and we don't look at it in a different way based on this country or that, this profile of the suspect or this. And we have been working for over 20 years, so we have seen many different situations, and I can assure you that yes, it has happened before that we have demonstrations and different ways of supporters showing their support to the suspect.
You know, supporters of the former President Duterte are known for their very passionate stance. It is also public knowledge that some have resorted to name-calling, issuing threats against those involved in the case, and even spamming the social media pages of the ICC judges. How is the ICC addressing this concern?
I think that the main thing that we need to understand is justice acts in an impartial way, and justice has to act in the time that is necessary for justice. We have to respect the process. It's not about being passionate. It's about being objective and impartial and applying the law and checking the evidence thoroughly and ensuring that the rights of the defense are respected and that the rights of the victims are respected. That's what we are working about. So we understand that there is always a lot of passion in the realm of social media, and we understand that by definition, the persons that are suspected by the ICC, they are suspected of very serious crimes and mass crimes. So by definition, they retain a certain amount of power and they have supporters. But we do not consider that this is that this should be something that would be kind of distracting our focus from